Do you want to hear directly from the ATO and leaders across the SMSF sector on the latest trends, tools, strategies and more to help you deliver seamless client experiences and generate impressive outcomes for your clients? The SMSF Advisor Technical Strategy Day will do exactly that. Our expert-led sessions will explore the changing legislative and regulatory landscape, arming you with the must-have knowledge to keep ahead, combat risks and reap new opportunities. Visit smsfstrategyday.com.au to learn more about our game-changing sessions and the experts leading them. Tickets are selling out fast, with only a small handful remaining in each state. Don't delay and miss your chance to attend.
This is a Momentum Media production.
The SMSF Advisor Show. Your expert insights into the biggest themes shaping the SMSF advice industry.
Hi everyone and welcome to the SMSF Advisor Show. I'm Miranda Brownlee and I'm joined by my co-host Aaron Dunn. Hi Aaron.
Hi Miranda, how are you?
I'm good, and yourself?
Not too bad. Getting back into the swing of things. We are into our new financial year and, legislation or bills are starting to drop and conversations are happening with clients about, new returns and new years and new opportunities, obviously with the 1 July 2022 changes. So plenty happening. And as is always the way, our first segment, we look at what is making news. So Miranda, what is making news?
Yeah, so there's been a couple of different things come out in the last fortnight, but one of the things that we saw was the class released their annual benchmark report. So it was kind of a return of the report they used to release quarterly, but in an annual version with a lot of additional commentary. So there was a couple of interesting insights in that one. One of the ones was the uptick in establishments, particularly from that younger age group, which is kind of driving down the average starting age for SMSFs.
Yeah, and this, we've seen this statistic over time with the ATO's data as well, those published quarterly statistics where we were seeing that average age drop from about 50 to under 50, and a lot of that is leading from this 35 to 44 age group, which appear to be taking in a large component of that growth within the SMSF sector. There'll be certainly different asset classes that they would be interested in as well. But we are seeing this generation that have had compulsory super for their entire working life. And it's only then when you start to couple two people together and you look at the ongoing imprint that technology is having within our sector, that you can start to see the fact that they have sufficient values to start to warrant self-managed super funds, and therefore wanting to take a greater control and decision-making process over that. So class in their annual benchmark report here has really validated a lot of the information that the ATO was publishing on a quarterly basis too.
Yes, and we also saw a bit of discussion in the report about a sort of drop on-time lodgements and some of the reasons behind that as well.
Yeah, so this again is a reflection of some of the ATO data that we've seen recently about how much practitioners were potentially behind. I think we've spoken about on the SMSF Advisor Show in the past too. We've not only seen a challenge for practitioners in throughout COVID generally, but availability of staff as well was one of the issues I think that they highlighted in that report. But also just the fact that we have this change in this year of auditors due to the auditor independence requirements and the expectations of I guess that change in auditor and what it means on the timeliness of completing the annual return. So there's probably a range of reasons that have created some of this decline in online lodgement. The challenge will be, I think, in the trend going forward to see whether that then improves once we see a settlement not only from a COVID point of view, but the economy, and then potentially what that means from staff and the independence requirements and implementation of that changed auditor regime from July last year.
Yes, it's all kind of had an impact. The other thing we saw come out was a couple of court cases. So one of those cases was to do with a trustee being disqualified. There was a number of issues with that particular fund, a number of different sort of breaches, and the tribunal upheld the decision by the ATO for that one.
Yeah, so this is where, again, we've seen a withdrawal of money, looking at not only the contraventions from SIS, but the application of the accessibility of that money. And what's interesting here is that the Commission has been very clear insofar that the benefit payment is to be treated as ordinary income. Now, we do currently have in draft form, and the final rule or determination is to be expected to be finalised later this year, looking at whether the Commissioner would be able to apply discretion to treat it other than assessable income in the hands of the individual, so either as a super benefit or a super death benefit. But naturally, within that determination, they look at a range of reasons as to whether it was in the effective control or not of the trustee. Now, this case is a very clear example of the trustee and the member knew full well what they were doing, and the fact that he went out and took that money, and I think he bought a Mercedes-Benz along the way in here as well. So the blatant, I guess, nature in terms of how that money was withdrawn has ultimately meant that not only was there contraventions from a SIS point of view and actions taken, but the fact that that individual will be assessed personally on that money with no concessions available to them as to what would ordinarily be provided under a superannuation withdrawal.
Another decision from the tribunal was to do with a auditor who applied for a stay of the decision pending their appeal of their disqualification for their auditor registration.
And this is a good example here of why we are seeing an increase in the level of documentation and support information that is required. What was put to task, I guess, here was the absence of sufficient information around the audit file. So it referenced things like the absence of an audit file confirmation as to the eligibility of the SMSF of the 3 audited funds, failure to obtain representation letters, failure to obtain market valuations, failure to obtain investment strategies, failure to obtain minutes. So these are all things that many practitioners out there that are engaging with auditors are seeing a significant ramp up of this activity. And it's this very reason, these sorts of decisions that the ATO as gatekeeper or as regulator, and therefore reviewing auditors and looking at the quality of the documents, if it is insufficient, they're then being referred to ASIC, and it is becoming very clear as to what the expectations are and must be. And therefore, this certainly validates that approach and the reasons why the AAT has made that decision in this case.
There was also another interesting case, which was around the treatment of pensions and lump sums that are received by members of super funds. And essentially, the applicant in this case had a different view of how it should be treated compared to what the ATO had assessed it as.
Yeah, so this actually goes back prior to the 30th of June 2017, when you could, and some people will remember, the fact that you could elect to treat the amount as a lump sum, even though it would count towards the minimum pension for the year. And ultimately, that's what they've tried to do, but tried to do it retrospectively rather than prospectively. And this goes back to the ruling in tax ruling 2013/5 that makes it very clear that if you are going to treat an amount as a commutation and therefore as a lump sum, that decision must be prospective to exchange the right for an income stream payment for the right to receive a lump sum. And ultimately what we had here was a finding after the fact that there could be an alternate way to treat the payment. It didn't. They then tried to then argue that they wanted to treat that amount in a particular way. But again, it is very clear that ultimately the decisions as to what a valid commutation is needs to be done prospectively and needs to follow the requirements that have been set out in the Commissioner's views, like I said, when a pension commences and ceases in 2013/5. Even though we're looking at a case here that goes back pre-30 June 2017, it actually has some really good information in it in the context of individuals that are looking to draw more than the reduced or more than the minimum pension each year, because the commutation rules around the treatment of it being that amount above the minimum to be a valid commutation, this decision confirms again that that decision must be done prospective. And if you don't do that prospectively, then you will not be able to characterize that as a lump sum, and therefore the payment of that will be treated as a pension. Now, the rules have changed insofar that that commutation doesn't count towards the minimum, as they were trying to argue as the law was at that time, rather than they didn't necessarily, because of the quantums of money, didn't need it to meet the minimum. It has context and relevance today as much as it did back then. So I cannot reiterate enough. And as we are at the start still of a new financial year, making that election prospectively around how those benefit payments are to be treated during the year, whether they are to be pension or how you deal with above amounts that are above, is critical to the implementation of that strategy. Because in a court of law, here is a perfect case that says doing that retrospectively will not stack up.
And I imagine once we move to the quarterly based reporting, that's going to be even more important to have that prospective pension documentation done.
Absolutely. And it needs to be irrevocable. It needs to select which income stream it's coming from. We had guidance in the lead up to the introduction of the transfer balance cap for SMSFs that needed to comply with that introduction of the $1.6 million and PCG 2017-6, I think it was, or 5. So there is a process that we need to understand and go through, and therefore documenting that decision correctly will play a very important role in ensuring that you get the right treatment based upon what you want to have happen.
So shortly we'll be joined by the ATO, who will be providing some information about the transition to the new TBAR reporting framework. But just before we move on to that, quick mention about our upcoming SMSF Advisor Technical Strategy Day. Got a raft of expert speakers lined up for that. And of course, we'll have you emceeing, Aaron.
Yes.
So that's being held in 3 states across October. And you can check out more information and purchase tickets on the website for that.
Yeah, and it'll be great to, again, have the ATO part of those events face-to-face. In addition, like you said, we've got some wonderful speakers that I'll get to share the stage with and introduce them. And obviously I'm touching on the topic of SuperStream and the challenges that presents as part of the SMSF Strategy Day. So, yes, if you haven't already had a look, go on to the SMSF Advisor website and find out more and enroll yourself for one of those events in Melbourne, Sydney and Brisbane.
So we're now joined by Dalila Vellotti, Client Engagement Director at the ATO. Dalila is responsible for administering the pension transfer balance cap in the superannuation business line. So a little while ago, we had an announcement from the ATO that from 1 July 2023, all SMSFs would move to a quarterly based TBAR reporting framework. Just to start off, can you give us a little bit of an explanation about what this means for SMSF practitioners and their clients?
Yes, thanks, Miranda, for that introduction. I'd like to begin by acknowledging that we're meeting here in Canberra, in Ngunnawal country, and pay my respects to the elders past and present. Also, I'd like to acknowledge the contribution of several areas across the ATO in our presentation today. So before I start, I'd just like to say if people would like more information on this podcast, it'll also be updated in the SMSF news that's available on ato.gov. Now, there's 2 key messages about this change, and I will go into a fair bit of detail on what it means. Now, the first 2 key messages to call out is that this is streamlining the TBAR reporting across all self-managed super funds. However, it will only affect self-managed super funds where all members have a total super balance of under 1 million and are not already reporting quarterly. And it'll only affect those members who have a retirement phase event to report. And it will not affect self-managed super funds who are already reporting quarterly. And the second key message is there's no additional reporting. It's a change to the timeline of reporting, which commences on the 1st of July 2023. Now, there's significant benefits for practitioners and their clients in having more timely information for individuals on their transfer balance cap, which is available on ATO online services through MyGov. Now, I'll explain these changes in a little bit more detail, what they mean. In terms of the timeline for reporting, what it will mean is that where a self-managed super fund has all members with a total super balance of under 1 million in the last financial year, they'll be required to report those retirement phase events on the TBAR on a quarterly basis from the 1st of July 2023. So the concession for annual reporting will no longer apply from the 1st of July 2023. So what that means in more detail is that any events that happen in this financial year or earlier financial years that are unreported and happen after the 1st of July 2023 and also happen in the first quarter up to the 30th of September 2023 must be reported within that first quarter, which is the 28th of October. And that will effectively mean from the 1st of July 2023, all self-managed super funds will be on a quarterly reporting requirement. And quarterly reporting means at the end of each 28 days at the end of each quarter, which is usually the 28th of January, 28th of April, 28th of July, and the 28th of October. Now, just going on a little bit more detail on which members it'll apply to in your super fund. So it'll only apply to members who are close to or who are in retirement and have a transfer balance account with the ATO and are managing a transfer balance cap. And they have any retirement phase events which have not been reported. So essentially, if you don't have any of these events to report, then this change will not affect you. Now, I'd just like to spend a little bit of time explaining why we made these changes.
So, Dalila, and this goes back to some consultation in December last year, if I recall correctly. So, so this feedback, I guess, where we've had since July of 17 or July 18, really it was, wasn't it, by the time we went through and there was an initial set of relief. So the feedback becomes really important here from what was consultation that has got to the ATO to this position. So back to you, because I think this is really important.
That's correct. So we were getting a fair bit of feedback that there was challenges that the annual reporting was creating, and that was creating two main challenges, which has led to this change. And we did consult as well on the change, and I'll go into some of the feedback from that consultation. But the initial feedback once we implemented the concession was that practitioners were finding it difficult to have visibility of the total super balance of all members to determine whether they were annual or quarterly reporters. So that was a challenge. And the other challenge is that there was delays. The annual reporting does create substantial delays in the reporting, although it is to be lodged with the SAR. In some instances, it was up to 18 months of delays in the reporting. Now, these had the impacts of those delays were poor experiences for clients, but also reverse workflows. Now, I have two examples to explain that, some of the challenges that we were hearing about the annual reporting cycle. Now, the first challenge was that where the clients were in excess of the transfer balance cap, they were incurring additional tax and they were unaware that they were doing so until the event was reported to the ATO. So with the annual reporting, there were often, as I said, up to 18 months a delay. And we at the ATO, we don't have any discretion to consider a different effective date than that was reported. So we would have to apply the effective date, and that often meant that people were in excess for a longer period than they needed to. So that was one of the big challenges and one of the reasons leading us to reconsider the annual concession. Now, there was one other scenario that I'd just like to talk about that creates a lot of challenges for practitioners to be aware of. It's when amounts are being rolled over from a self-managed super fund to an APRA fund. What we're seeing is that the APRA fund's reporting those rollovers within 10 days, and the ATO will apply this data to the transfer balance account. And what immediately happens is the individual goes into excess. And it's because the corresponding transaction is not reported to the ATO. And that's the annual concession allows that. But what was happening is the individual was in excess and surprised by an excess determination. They'll often contact us. We'll have to spend a bit of time letting them know what they need to do, and they will bring the practitioner to remediate that and to actually get the self-managed super fund to report earlier. So they're the two main instances. Now, the important thing to note is with quarterly reporting, that should address that problem with the rollover. And this is another reason why one of the reasons we've led to this, one of the benefits of this earlier reporting.
So, Dalila, that'll limit the exposure, won't it? I mean, the reality is SMSFs, they could go to ultimately, and they've got the discretion to report in a more timely basis. But the reality is APRA funds have an obligation to report within that 10-day timeframe. Most of them are probably reporting that night. So it is incumbent upon the trustee / tax agent, whoever is doing that reporting, to ensure that it is done on a timely basis. But the quarterly reporting, I guess, just limits the potential impact that will occur in that scenario.
That's correct. So if the amount isn't reported within the timeline, the individual will get the determination, but then there's time for the individual to contact the fund for the reporting to happen without too much reverse workflows. Because I think the thing is, you're trying to, once the commutation authority is issued, then that has more, and that's where the time delay leads to that sort of more difficult scenario.
Yeah.
So just going on from that, so what we have sought to do is we've listened to the feedback. So we did hold a consultation and released a paper. So if you're interested to find some more example of some of the concerns leading to the reason why we changed the reporting, they are in our consultation paper, and you can access that on the ATO website. So the main reason was to reduce the complexity as well as to provide benefits for the clients. And finally, I just wanted to call out that the change to the streamlining has no change on the obligation to report some events earlier. There is legal requirements to report some retirement phase events earlier, and that's when an income stream needs to be commuted in response to an excess transfer balance determination. Those ones are 10 days. You need to report that 10 days after the event occurs. And also in response to a commutation authority, that needs to be reported as required under the law, which is 60 days.
So the other thing there, more a practical observation from my point of view, is if we go back to the introduction of these measures and we look at the time period that's coming now, there is a much larger cohort of tax practitioners and therefore SMSFs that actually have more real-time reporting available to them in the context of their software. We know that there is probably north of 450,000 funds now using cloud-based SMSF-specific software. So I think to the technical points that you raised, absolutely, but I also think there is a practical overlay to this as well, that the industry is much better equipped now to be able to handle this because of the advancements that we've seen in technology in the sector as well.
Yes, that's good to hear.
Can you give us a bit more clarity around what the lodgement requirements will be where an annual reporter is transitioning over to the quarterly based reporting in terms of the lodgement requirements and how that'll kind of work with the timing and the start date?
In terms of, I'll go into a little bit more detail because I have a good example. If the individual starts a pension on 1st of July 2022 this year,
yep,
and all the members have a total super balance of under 1 million in the last financial year, so under the current reporting arrangements, they would be eligible for the annual reporting and they wouldn't have to lodge their TBAR until they lodge their annual return. So that could potentially be May 2022 with extended lodgement period. So with this new reporting, which starts on the 1st of July 2023, the important thing to note is that the annual reporting concession is no longer available. So what this means is that all events must be reported, being all unreported events from the 1st of July on a quarterly basis. So that means that if there is any unreported events up to the 30th of September, then they must be reported by the 28th of October.
So the 1 July 2022, so it's happened last month. They started a pension last month. Their latest reporting date would no longer be the SMSF annual return date, but will be the 28th of October 2023.
That's correct, yes, because from the 1st of July, that concession has been removed. And that reduces a lot of complexity. It's intended to be very straightforward so that once that period starts, anything unreported needs to be reported. Yeah,
so there is any reporting that falls under the current annual reporting requirements for 2022-2023 financial year, and then obviously thereafter will up until September of 2023 must have all of that reported by the 28th of October 2023.
That's correct. Yep. And there's nothing preventing funds from doing it as soon as they can, and that's the message as well, is start looking at it now. We listened to the feedback that we got from our consultation, and people, practitioners, industry and community said they needed time to prepare. So this is effectively a year to prepare for this
transition.
So it's not a case of, okay, I've got the annual, I can just rely on the annual. It is a case of, no, you need to get your reporting all up to date to be able to report quarterly from the 1st. And it is not dependent on when the event happened. It's dependent on the concession. So effectively what had happened when the transfer balance law commenced in July, a concession was given, and what has been removed is that concession. So regardless of when the event happened, it has to be reported quarterly from the 1st of July. And as I said, for that first period, most funds will have until all events up to the 3rd of September 2023, and then they have to the 28th. So we would encourage practitioners to understand what the changes mean, identify the clients that are impacted, potentially contact those clients and let them know about this change, and encourage them and also get yourself ready to get your reporting in as soon as possible and not leave it as with anything to the last moment.
Yeah, and that's really important, that it's not as if people won't have what I would call internal systems in place already, because they would likely have clients that will have quarterly obligations. So it will, over the next 12 months or so, really enforce the need for people to take a proactive look towards the administration and compliance of the funds. And I think you rightly said, just ensuring that the communication is happening with the clients, and that the information, however they are collecting that information from the clients, whether it's through data feeds that they're getting or just other communication, that that information is arriving in a timely fashion to allow them to report within the timeframes that will be imposed on them moving forward. So, it's, to me, I think it's a there'll be people that'll be pretty grumpy about it, but I also think it's a good thing as the technology is moving. Most people in this segment are moving with it, and we are seeing a real shift in the way that they're undertaking that work. So it should, in my view, kind of fit in with a lot of the systems and processes that firms that have a SMSF specialisation are really looking at. The challenge, I think, will sit in a smaller cohort of people that might be chasing their tail in some of the work that needs to be done, and they will need to look at their systems and processes to be able to deal with that.
Yeah, and there is benefits for the clients which practitioners can inform them of, and particularly coming up this year. So the transfer balance account is only ever based on the information reported to us, and each individual will have their own personal transfer balance cap on ATO Online, and it is likely this year that we might see the cap indexed, the unused caps indexed. Just looking at the CPI figures for June, it's likely December will be on or about the same, and there will be an increase in the cap on the 1st of July 2023. So that is another incentive to get your reporting in, because we can only index the cap based on the data that we have. Yep. So if you get your reporting in, you can get it timely in and meet the quarterly reporting, but you can also meet the requirement for indexation, and they will have most up-to-date information on their unused cap, and it's indexed. Yep, and that cannot, I mean, that's a significant benefit you can tell clients.
We've obviously just had the announcement that we will move to quarterly based reporting, but is there any sort of plans that the ATO has to move to perhaps tighter timeframes in some point in the future for SMSFs?
Great question. We've listened to the feedback from the consultation early this year, and most funds advisors and community didn't want more frequent reporting at this stage. So at this stage, there's no intention to move to more frequent reporting, such as monthly.
And I think that certainty is important to hear as well. So I know it was quite controversial at the time. There was a lot of argy-bargy back in 2017-18 trying to get to the framework that we had at that point in time. So, and we did have a level of certainty here. So to hear that level of certainty again, I think will put the industry in good stead to get the ship sort of steering in the right direction they need to deal with it on a quarterly basis. And many funds, of course, have other quarterly obligations in any event anyway, in terms of withholding or GST and so forth as well. So again, I don't think we're going to be moving to a system that for a lot of people will be very different to what they've been doing otherwise historically.
Yes.
So is there any other, I guess, final things that you want to mention? Obviously you've shared some great insights with us today. So to that, we are certainly grateful for the time. But is there any other, I guess, final messages from the ATO's point of view in respect to this topic that you'd just like to share with our audience today?
Yes, there is just a tip that I wanted to talk about, was that we've heard some practitioners are interested to know how to value a pension when starting it partway through the year.
Yep.
And as quarterly reporters currently have access to use our valuation guidelines on self-managed super fund, which is available on the ATO website. So with annual reporters who now move to the quarterly reporting, they will also able to access those guidelines. And what those guidelines enable the practitioner to do is to use a reasonable estimate of the value of the income stream where it started partway through the year.
Yeah, and that is going to be something that I find practitioners struggle with, because they want to feel like so a really good example is this period we're in right now. So 1st of July, they are intending on starting the income stream, but for whatever reason, tax statements and other things, they can't complete that work until some stage after the 28th of October. So therefore, their expectation is, well, how can we actually get that reporting done within that prescribed time frame if we don't have a value that has been audited and set and so forth? And the ATO has been very clear on this for some time in their view, to say, well, as long as you use evaluations supported by objective and supportable data, then that is the foundation for you to report the commencement of that income stream. So therefore the documents and for TBAR purposes, that is the value that needs to be done. And from my understanding, the only time that you need to go back and specifically refer to the value for the accounts in the fund from an opening balance is for eCPI purposes when you look at your tax exemption claim. So it will impose on people preparing financials and pensions, and therefore TBAR, to sometimes be using and relying upon those market value requirements to determine that commencing value, and in particular where the information to complete the statutory accounts of the fund will be unavailable prior to when the due date of that will be.
There's also a few common errors that we see that, if I could have the opportunity to just share them just to help practitioners out a little bit. As I said, we do see the rollover from a self-managed super fund to an APRA fund, and we do encourage practitioners to have a look at that and see if they can try and report those as quickly as they can. The other one we see is that we do have TBAR reporting instructions available on our website, and one of the common errors we see is that where we issue a commutation authority and the funds in the accounts have been exhausted, often the fund will report that it's a commutation in part and that's all. What they need to also do there, and these are in our instruction, is also report that the account is closed. Otherwise, the ATO doesn't know that it is closed. So what will happen is we'll reissue a commutation authority. So when you undertake a commutation in part where the funds have been exhausted in that account, then please do close that account, and then that should resolve the issue. And the other thing we see is just the events, the reporting events used for TBAR. There's one common area that keeps coming up is that when funds commute an amount, instead of using the event member commutation, they often use the event income stream stops being in retirement, which that can only be used if the income stream is no longer meeting the minimum pension payments. And so that's then creating these flow-on effects for eCPI. So we do say if it's a member commutation, use the correct event. Using other events does have flow-on effects and reverse workflows.
Very good. Excellent. Well, thank you for your time. We could probably talk for a hell of a long time on this topic, but I think from both Miranda and myself, it's been great to have the ATO come on the show and as we're going through a period of transition to give everyone some insight into, I guess, not only why, but how our audience will need to understand the transitional aspects of this as well. So, yeah, from everyone here to yourself, Dalila, and the rest of your team, a very big thank you for being a part of the show. And no doubt, as things will change, as they always do in the future, we hope to get you on again in the near future as well.
Thank you very much, Miranda and Aaron. That was good.
Excellent. Thank you. So, Miranda, that was hugely insightful from Dalila in respect to those changes that we're going to see from the 1st of July 2023 for transfer balance account reporting. What were some of the key takeaways for you?
Oh, it was definitely great to have that clarification from her around how those unreported events from the 22-23 year are going to work in the new framework. And, I think it's good to have an understanding of that now.
Yeah, for me, that clarification is great. I mean, it is important to remember that we are only looking at the reporting based upon when events occur, but the communication process will become so critical to the success of that. And many firms, I think I mentioned in there, it's not as if we're having to reinvent the wheel where we're moving entirely from annually to quarterly. We already have clients in the quarterly framework. So it is important that then everyone is coming along for that ride now rather than just a select group. So communication and looking at internal processes here will become key.
Yes, it'll definitely resolve some of those issues she was talking about with the double reporting. So definitely a positive with that.
Yeah. So as is always the way, if people have got any questions or thoughts on topics or speakers, how can they get in contact with us?
So you can get in contact at editor@smsfadvisoronline.com.au.
Well, thank you everyone once again for joining us for this week's SMSF Advisor Show. We hope to see you again, or actually you'll hear us again at our next event in a fortnight's time. Take care and bye for now.
Imagine being rushed to hospital.
Yep.
And your life changing in an instant. Imagine going through hundreds of tests and 46 weeks of chemo. Now imagine you're a child. That's why Starlight exists, to bring happiness to seriously ill children. Please donate at starlight.org.au.